number 2 and issue number 3. The first issue here is whether the present petitions are Gandhi versus Union of India, 1978, 1 SCC 248, where the Honorable Supreme Court held that Article 32 of our Constitution grants entitlement to every citizen to approach the Supreme Court when their fundamental rights are at stake. It's submitted before this Honorable Court that the present petitions are maintainable, and this is substantiated using a fourfold argument or option. Firstly, that the petitioners possess sufficient interest and local standards. Secondly, the violation of fundamental rights involve writ petition under Article 32 of the Constitution. Thirdly, Harbour Dynamics International qualifies as an instrumentality of the state under Article 12. And fourthly, the existence of an alternative remedy does not impede taking a writ petition under Article 32. So firstly, it is humbly submitted that the petitioners possess sufficient interest and local standing. In the case of Romy Stafford versus State of Madras, it was held that the Supreme Court, as the defender and guarantor of fundamental rights, is amenable to judicial petitions seeking protection against the infringement of fundamental rights. May I direct your Lordship's attention to the case of People's Union for Civil Liberty versus Union of India and others, AIR 1997, SC 568. Here the Supreme Court in this case emphasized the collective responsibility of the citizens to protect the fundamental rights. It was held that the right to approach the Supreme Court for the enforcement of fundamental rights is not restricted to the aggrieved party alone, but it can be exercised by public-spirited individuals or organizations acting in the interest of justice. Your Lordship, the basic principle of local standing to initiate a writ under the Honorable Court is that there should be a violation of fundamental rights. Your Lordship, in this present case, the State to Transfer the Sea, which is an NGO, and Equatorial Serenity initiated writ petition to protect the interests and welfare of the people. They have initiated this with a noble interest, Your Lordship, and thus the whole organization the Council would like to establish that the petitions possess sufficient interest and local stand. Secondly, Your Lordship, the violation of fundamental rights involve writ petitions under Article 32. This Honorable Court, in its role as sentinel on the queue Vivek, holds an indispensable duty to protect the fundamental rights of the citizens. In the case of Maneka Gandhi versus Union of India, it was held that Article 14 strikes at arbitrariness. Your Lordship, the state has failed to provide promised preferential employment and customary fishing rights, and this undermines the equal protection of law. And moreover, the proposal of exclusion which has been brought up by the Harbour Dynamics International is arbitrary, evasive, and unreasonable. Secondly, the encroachment on the fundamental freedom of profession guaranteed under Article 19 clause 1 clause D is evident in the failure to provide customary fishing rights, preferential employment laws. And finally, the loss of life and environmental degradation violated Article 21 of the Constitution. Furthermore, Your Lordship, it comes as a profession and occupation, my lord. Because in this particular case, understanding was agreed upon between the state and the people of Eldoria who were in the coastal region, and this was done because they were scared whether they lose their livelihood, my lordship. And
Because in the national profession, there are so many being about bar councils, then medical council, medical council is here. Whether any criteria to become a profession or to distinguish profession and occupation.
Economics needs ignorant results. Thirdly, experience is an instrumentality of state under Article 12 of the Constitution. The definition of state under Article 12 is not restricted to mere governmental entities, but it also includes instrumentalities and authority vested with the substantial execution of governmental functions. Here we are trying to establish that Hybrid Dynamics International is an instrumentality of state as it comes under other authorities. And this is established by using the case of R.D. Shetty versus International Airport Authority of India, 1979, AR 168. The exercise authority over critical aspects of seaport, including infrastructure, environment, security, and development, aligns with the performance of governmental functions, and this satisfies the functional character test. And the role played by the government of Cambodia in providing land and ensuring public utility services without financial liability satisfies the financial assistance test laws. And thirdly, the close collaboration between the Harbour Dynamics International and the government signifies signifies a level of state control and management relations. And fourthly, the contractual autonomy which has been awarded to the Harbour Dynamics International, which actually gives them the right to withdraw with notice and arbitration for compensation, suggests a structured persuasive control laws. And fourthly, the existence of an alternative remedy does not impede seeking a writ petition under Article 32 of the Constitution.
Not ordinary remedy. Constitutional remedy itself is available.
Yes, Your Lord.
226 is there.
Yes, Your Lord.
And this honorable court, several occasions stated that it is better to approach the High Court first under Article 226
Yes, Lord.
before then we approach the Supreme Court. So many decisions, including PLD.
Because Lord,
Yes, what is the difficulty approaching the High Court?
because Your Lordship, there is no imperative to first seek the High Court or exhaust the remedies under Article 226 before approaching the Supreme Court, Your Lordship. Your Lordship, the mere presence of an alternative remedy cannot ipso facto serve as a valid and sufficient ground for the dismissal of a writ petition under Article 30. Yes, Your Lordship. Your Lordship, in the case of Bandhu, Your Lordship, Your Lordship, in this present case, this is a thing. Your Lordship, Your Lordship, because approaching the Honorable Supreme Court under Article 32 for the protection of fundamental rights. Your Lordship, anyone to done. Your Lordship, Your Lordship, particular. Your Lordship, could you control that? One day, they go back to the voice, so on to that. Your Lordship, because Article 32 of the Constitution, Your Article 32 is the fundamental right, and 220 is the constitutional right. 220 is the constitutional right, Your Lordship. Because Your Lordship, in this present case, there's national importance and there's a substantial violation of fundamental rights. This is the reason the petitioners have approached the Honorable Supreme Court. And in the case of Morsa versus Union of India, it was held that approaching the Honorable Supreme Court under the fundamental rights is a fundamental right in itself. The Supreme Court of Meridiana has the autonomy to hear and decide cases related to fundamental rights without the need for prior adjudication in the lower courts. Much is learned. Thus, it is humbly contended with due deference that the writ of mandamus Your Lordship, here this is a case of national importance, my Lord. Here the people have had economic and social loss, and the people of coastal state of Eldoria are suffering. Your Lordship, here since it's a case of national importance, the petitioners felt the need to approach the Honorable Supreme Court directly, Your Lordship. And since there is no imperative to go to the there is still and your lordship in the case of Kottayakil Kochuni Mumbil Nayanar versus State of Madras, AR 1959, SC 725, it was held that the right to approach the Supreme Court directly under Article 32 stands independently, irrespective of the availability of alternative legal remedies. Thus, it is humbly contended with due deference that the writ of mandamus and PIL are justifiably maintainable under the Honorable Supreme Court of Maryland. The Council seeks the permission to move to the issue number 2. The second issue here is whether there is a violation of fundamental rights, namely Article 40, 19, and 21 of the Constitution of Meridiana. May I direct your Lordship's attention to the case of Ramdas Athwale versus Union of India and others, AAR 2010 SC 13. The Honorable Supreme Court held that the infringement of fundamental rights enshrined in Part 3 of the Constitution is impermissible and necessitates a prompt and effective remedy. Your Lordship. Your Lordship, in this present case, Article 14, which is the right to equality, substantially violated. Your Lordship, the right to equality or the equality before law means that the state has a specific duty to refrain from action which is discriminatory in nature. Article 14, which is rooted in rule of law, is acknowledged as a basic feature of the Constitution, Lordship. It's true that the state is permitted to exercise differentiation among individuals who are differently situated, but it should have a rational nexus to the object sought in also. You know? Yes, sir. Golden family. Golden family. You know, first of all, in the case of Article 40, the state, in this present case, the state had signed a memorandum. Your Lordship, in this present case, the state had signed a memorandum of understanding with the people of Eldoria, where they had promised customary fishing rights and preferential employment opportunities. Later on, the Harbour Dynamics International, which is the company authority for the construction of seaport, they brought a proposal. Maneka Gandhi versus Union of India. Much obliged. AR 1978 SC 597. Pardon me. Your Lordships, in this present case, Your Lordships, in this present case, Your Lordship, in this present case, in the case of Maneka Gandhi, who was the Union of India, she went to the court because her passport was impounded by the Passport Authority of India. The what provision passport is known? The what provision passport is known? It was impounded under the ground mentioned was for public interest allowed. Okay. See. Your Lordships, the proposal of exclusion put forth by the HDI is not based on a reasonable classification. Your Lordships, in the proposal of exclusion, it was stated that when such exclusion aligns with strategic industry development goals, where the inclusion of external expertise and advanced technology is deemed essential for the progress of fisheries-related industries, largely to you know, how important is it? Your Lordship, your Lordship, in this present case, first of all, the right to equality under Article 14 is violated because there is no the proposed exclusion brought forth by the HDI is not based on a reasonable classification and a rational nexus to the object sought, and moreover, the proposal of exclusion is arbitrary, evasive, and unreasonable. Your Lordship. And secondly, there is a violation of Article 19 of the Constitution because the restrictions imposed are unreasonable, pardon me, my lord. The restrictions imposed are unreasonable and it is violative of 19 clause 6 of the Constitution, and moreover, there is no adherence to the doctrine of proportionality. And it is also violative of Article 21 of the Constitution because due process is not followed. Due process has not been followed. Due process of law has not been followed. The council seeks permission to continue. The Lordship, in this present case, the freedom of profession under Article 19 clause 1G is violated. Article 19 clause 1G of the Constitution ensures every citizen the right to freely pursue in the occupation of their choice. In the case of Sagir Ahmad versus State of UP, 1955, 1 SCR 707 held that this provision was shield to protect individuals from the state actions that might impede or impose limitations on ability to the freedom of professional knowledge. Here, the non-fulfillment of the memorandum of understanding and by the proposed exclusion, there has been a substantial violation of 19 plus 1 clause. This is because the restrictions imposed are unreasonable enough. The proposal of exclusion does not strike a balance between the guaranteed fundamental freedom of profession and the reasonable restrictions which have been imposed in 19 clause 6 of the constitutional law. And finally, there is also a non-adherence with the doctrine of proportionality laws. The blatant disregard for the doctrine of proportionality is evident in both the non-fulfillment of the MOU and the proposed exclusion laws. Lordship, in the case of Lordship, in the case of K. Swami versus Union of India, 2019 10 SCC 1, the legal principle of doctrine of proportionality requires that any state action curtailing individual rights must be proportional to its intended objectives. Your Lordship, it states that any restrictions on fundamental rights must align proportionately with the legitimate objectives sought to be achieved. Lordship, in this present case, the proposal of exclusion restricts the local people from employment opportunities solely based on the availability of cheap laborers from northeastern states. Here, the proposal of exclusion is not based on a reasonable answer or a rational nexus to the object sought, Your Lordship. Here the sole criteria that has been the provocative motive nature of the HDI, Your Lordship. The Lordship in this present, Your Lordship in this present case, the state is bound by the promissory estoppel, Your Lordship. The state's failure to fulfill the specified commitments outlined in the memorandum of understanding invokes the legal doctrine of promissory estoppel, Your Lordship. We listen to the question fully. Then they hear the question properly. Wait. Your avocation is switching. Which can cover the pressure. You got insist that yeah. But Your Lordship, when the construction of the seaport had began, the people had protested, and thus a memorandum of understanding was agreed upon between the state and the people. And at that time, they were promised customary fishing rights, Your Lordship. And Your Lordship, but here the customary fishing right has is definitely restricted to their locality, Your Lordship. And that is why they say that you got it. No, Your Lordship. The the petition would like to contend that the project should go on, the people should be considered, Your Lordship. The 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 the, the people were never against the construction once the memorandum of understanding is agreed upon. Once the memorandum of understanding is agreed upon, they supported the project. And Your Lordship, the right to livelihood is violated in this present case. And there is also environmental degradation. And Your Lordship, coming back to my contention, here, when the memorandum. Then migrate there. But Your Lordship, it is a custom, Your Lordship. It is been. So then make me longer. Like, yeah. The legal question, answer it legally. You're coming to that point. Answer that. Yes. Because Your Lordship, it is not based on the doctrine of proportionality or the Wensbury principle, Your Lordship. And And the Lordship indicate Article 19 clause 6 of the Constitution permits the state make suitable restrictions when it is of public interest. No public interest, Your Lordship. Your Lordship, because this education is proportionate exclusion. Your Lordship, this is national importance, but the council was referring to the proportionate exclusion, Your Lordship. Here the proposed exclusion is brought up by the HDI. It had all these developments and technology and external investments. But what they have done is they have solely brought cheap laborers from the northeastern state without considering the people of the rural areas. I am running on. We're eating on the diet of the other towns. Your Lordship, restricting the natives from employment is not a public interest, and this is discriminatory, Your Lordship. And this is discriminatory, Your Lordship. Okay. Yes. If there are still no further queries, the council would like to invite my co-worker. What further queries? No. What further queries? D02. Speaker number one. D02. 02 S1. D02 speaker number one. Speaker number one. And it is and thus it is humbly submitted for the honorable court that the present petitions are maintainable and there is a violation of fundamental rights, namely Article 14 and 19 of the Constitution of India. It is an honor to ask you to tell us. Your Lordship, Your Lordship, this is council number. Yes, Your Lord. Your Lordship, the council seeks permission to begin. So the light, Your Lordship. Your Lordship, this is council number 2 on behalf of the petitioners. If Your Lordships have no further queries regarding the submissions of my co-counsels, the council seeks permission to proceed. Much obliged. Your Lordship, for my first submission, the council seeks to establish that there is a violation of Article 21 of the Constitution, and Your Lordship, this submission is substantiated through a threefold argument, Your Lordship. That firstly, the right to life and liberty is transgressed, and secondly, Your Lordship, that the right to safe environment and sustainable development is undermined, and lastly, Your Lordship, that the right to work and livelihood is imperiled, Your Lordship. Your Lordship, Article 21. Your Lordship, Article 21 embodies the sacred right to life and liberty. Integrity must be upheld without any breach, Your Lordship. Your Lordship, it is humbly submitted that unconventional construction undertaken by the respondents have resulted in environmental degradation of the navigation channels, leading to perilous conditions that have resulted in the tragic loss of life, Your Lordship, which has been reported that there was a loss of 7 lives of fishermen in the nearby Savaria Harbour, Your Lordship. Your Lordship, therefore, it is humbly submitted that the respondents being made liable under the NATO principle, Your Lordship, which has been reiterated in the case of Donov versus Stevenson, 1932, AC 562, Your Lordship. Your Lordship, this principle underscores the very idea that the reasonable care should be exercised to prevent harm to those in proximity, Your Lordship, and to adjacent regions, Your Lordship. Therefore, it is humbly contended before the Honorable Court that the actions of the respondents have resulted in the harm that is caused due to the unconventional construction undertaken by the respondents, Your Lordship. Your Lordship, furthermore, it is humbly submitted that the government of Eldoria and its instrumentality, HDI, should be made absolutely liable for the loss of life and environment environmental degradation that is stemming from the seafood and township initiative, Your Lordship. This contention is substantiated on the contention that it falls within the concept of a inherently dangerous activity, thus triggering the doctrine of no fault liability, Your Lordship, which makes them absolutely liable for the harm that is caused. Yes, Your Lordship.
Regarding absolute liability, that is okay.
Yes, Your Lordship.
But the first argument, the non versus sir.
Yes, Your Lordship.
Relationship between manufacturer and authorized purchaser.
Yes, Your Lordship. Yes.
That is a doctrine.
Yes.
Here, who is a manufacturer? Ultimate property.
Your Lordship, we are not applying it as such as a manufacturer and the user, Your Lordship. Lie is that the HDI who has undertaken this unconventional construction should have taken the reasonable care to prevent to those in the neighboring adjacent areas. Your Lordship, it is pertinent to note that.
Then the principle of strict liability for absolute liability
Your Lordship,
may be applied. Then what is the logic in applying this Donovan versus Stephenson's doctrine?
Your Lordship, the council submits its doctrine because the fact that the loss of life has taken place in the nearby Savaria Harbor, not in the Alex people. So the council would like to emphasize on the note that this environmental degradation and effect of this unconventional construction has also been affecting the nearby harbor, Your Lordship. That's why the council has got this doctrine, Your Lordship. Your Lordship, the query was whether a neighbor principle was applicable to the present case. Your Lordship, the council says, can you please repeat the question again?
So, your argument is that only this neighboring principle, that alone is applied to this case.
No, Your Lordship. We are arguing neighboring principle makes them liable, and the liability is absolute liability, Your Lordship. We are conferring the liability, Your Lordship, that they are absolutely liable, Your Lordship, for the loss of life and environmental degradation that has arisen due to the unconventional construction, Your Lordship. That is my submission. Thank you.
These are important cases related to absolute liability.
Absolute liability. There's a plethora of cases, Your Lordship. The council. Yes, Your Lordship. The council. Like some. Yes, Your Lordship. The council like some NC Mehta was given in India 1998. 9 SEC 59 case. This is the Green Belt Taj Mahal case. Your Lordship, there's a lot of NC Mehta cases which has laid down the principle of absolute liability, Your Lordship. Yes, Your Lordship. Your Lordship, that is Ryan versus Fletcher, Your Lordship, which convert from strict liability, the doctrine of absolute liability was derived, Your Lordship. The council seeks permission to proceed. Much obliged, Your Lordship. Therefore, it is humbly submitted before the Honorable Court that the respondents are absolutely liable for the harm caused, Your Lordship. Your Lordship, moving on to the second leg of my argument that the right to safe environment and sustainable development is undermined, Your Lordship. Your Lordship, in the expansive interpretation of Article 21, it includes the right to live in an environment which is conducive for human well-being, Your Lordship, and the right to live in a sustainable development. This has been reiterated in the case of Velu Citizens Welfare Forum versus Union of India, 1996 5 SEC 647, Your Lordship. So this case has laid down the principle of sustainable development, Your Lordship. And what the petitioners are contending that this unconventional construction, which has led to the significant environmental degradation, Your Lordship, of the navigation channels, which has led to the bringing of substantial sediments into the navigation channels, which has led to the rise in water levels, thus making it very difficult for the navigation channels to navigate through, and thus imperiling the right to sustainable development and environmental degradation. Also, loss of life has stemmed from the same cause, Your Lordship. So, Your Lordship, therefore, it is humbly submitted that the right to safe environment and sustainable development under Article 21 encompasses the right to live, and therefore the respondent should be made liable for the harm that is caused, Your Lordship. Moreover, Your Lordship, counsel would like to submit that the respondents have also violated the two pivotal principles of environmental law, Your Lordship. That is the precautionary principle and the polluter pays principle, Your Lordship. Your Lordship, moving on to the precautionary principle, which mandates the adoption of preventive measures in situations where there is a potential irreversible harm, Your Lordship. And Your Lordship, it can be noted in the fact of the present case, Your Lordship, there have been no precautionary measures undertaken by HDI, Your Lordship. And therefore, this is the foreseeable consequence of the activities that is undertaken by them, Your Lordship. And moreover, Your Lordship, the council would like to state the polluter-based principle, which has been reiterated by the court in the case of Indian Council for Environmental Legal Action versus Union of India, 1996 AIR 1446, Your Lordship. And Your Lordship, this is the Bichari pollution case, Your Lordship, which laid down the principle that a person, there will be responsibility to those who cause environmental harm to bear the financial cost for remediation, restoration, and compensation to the affected parties, Your Lordship. And moreover, Your Lordship, the council contends that the respondents have failed to undertake an environmental impact assessment, Your Lordship, which has been mandatory in the EIA notification 2006, Your Lordship. And therefore, this breach is a blatant violation of Article 21 of the Constitution, Your Lordship. And moreover, the council would like to also submit, sorry, Your Lordship. Moreover, the council would like to also submit the public trust doctrine, which has been laid down in the case of MC Mehta versus Kamal Nath and others, 1997 1 SEC 388, Your Lordship. And under this case, the court has stated, Your Lordship, MC Mehta is the lawyer, Your Lordship, who has undertaken a lot of cases, Your Lordship. No, Your Lordship. No, Your Lordship. Much obliged, Your Lordship. Your Lordship, this doctrine imposes a fiduciary duty on the state to have an obligation to conserve the natural resources, Your Lordship. That is what the council is trying to establish, that the respondents are bound to cover the expenses and they are absolutely liable for the environmental degradation that has arisen, Your Lordship. Your Lordship, moving on to the next submission, that the right to work. Yes, Your Lordship. That the right to work and livelihood is imperiled, Your Lordship. Your Lordship, therefore, it is humbly submitted that the right to life encompasses more than mere survival. It's not mere animal existence, Your Lordship, which has been laid down in the case of Karat Singh versus Union of India, 1963 AIR 1295, Your Lordship. And Your Lordship, Your Lordship, the council is unaware of the fact. Huh? Your Lordship, the council has referred to a textbook, Your Lordship. Much obliged, Your Lordship. The council seeks permission to proceed. Much obliged, Your Lordship. Therefore, in the factual context of the present case, Your Lordship, this unconventional construction thus catalyzed the incidental loss of livelihood, Your Lordship. And therefore, it is humbly contended by the petitioners, Your Lordship, that this damage is a purposeful neglect of their constitutional entitlement, Your Lordship. If Your Lordships have no further queries regarding the submissions of issue number 2 regarding Article 21, the Council seeks. No, Your Lordship, I was trying to establish that there has been environmental degradation due to the unconventional construction. Your Lordship, as the Council, Your Lordship, if you could refer to move proposition. So therefore, the Council seeks to establish this subjective sequence falls in the concurrent list under Schedule 7, entry number 31, Your Lordship. Therefore, the Council seeks to establish that conferring of exclusive power solely to the government of Territoria. This undermines the very principle of cooperative federalism. That is what the Council is trying to establish, Your Lordship.
So it's a ground for judicial review.
The amount of submissions coming up, Your Lordship, there is violation of fundamental rights due to the provisions of the Act. Your Lordship, judicial review is when the judiciary has the right to review any actions that is undertaken, Your Lordship. And against statutory action. Much obliged, Your Lordship.
What was the ground for judicial legislation?
Also, there is a violation of fundamental rights. That is one.
Only one ground. Only one ground.
And there, if it does not follow, the council seeks permission to move on. Getting the particular points.
That is very fundamental. Anyway.
Much obliged, Your Lordship. The council seeks permission to move on. Your Lordship, the next contention is that Section 7 of the Impugned Act confers excessive power to the authority, Your Lordship. Your Lordship, Section 7 of the SCID Act is for the powers of the that is granted to the authority, Your Lordship. Humbly submitted that there is a concerning degree of excessiveness, Your Lordship, and the foundation. Yes, Your Lordship. Your Lordship, excessive power. Your Lordship, that was the answer of before. Okay, absolutely, Your Lordship. Yes, sir. Yes, Your Lordship. Absolutely, Your Lordship. Indeed, Your Lordship. Indeed. It can be arbitrary or invasive or excessive. Permission to proceed, Your Lordship, for your. Your Lordship, the query, I believe the query was what are the grounds for judicial review? And the council has submitted that there is a violation of justice and due process, and whether if it is conferring excessive power to any authority. Oh, yes, Your Lordship. The council is moving forward to the next argument, Your Lordship. Therefore, it violates the foundation principle of separation of powers and checks and balance, Your Lordship. Your Lordship, separation of powers as laid down in the case of the Bharati versus State of Kerala 1973 4 HEC 225, Your Lordship. Your Lordship, moreover, 50 of the Constitution emphasizes on the principle of separation of powers also, Your Lordship. Therefore, it is imperative to maintain an integrity between the independence of all the three functions of the that is the legislature, executive, and judiciary, Your Lordship. The three organs, Your Lordship. Much obliged, Your Lordship. Therefore, Section 7, by conferring extensive power upon the authority, Section 7 bestows the authority and unprecedented array of powers, Your Lordship. Then, moreover, Your Lordship, this comes counter to the principle of separation of powers. Your Lordship, it can be pertinent that Section 7 clause J, which states that such other power may be necessary for the realization of the seaport, and also, Your Lordship, an absolute authority has been conferred, and Section 7 clause C also states that any other person can. Your Lordship, are you referring to the principle of harmonious construction? No. The council is not getting the query. Can you please repeat again? Okay, Your Lordship. Okay, Lordship, this Section 7 clause D confers any other person the right to undertake the matters incidental and ancillary thereto. So the HDI has the authority to confer such powers to any other authority which has been stated in 7 clause D. So, Your Lordship, the council would like to establish that the Section 7 of the SCAD Act is conferring excessive powers on the authority, Your Lordship. Your Lordship, moving on to my next argument, that Section 7 also. Section 7 also violates Article 14 and 21 of the Constitution. Your Lordship, Section 7 Clause B states that determine the terms and conditions as it deems fit, Your Lordship. This jeopardizing the right to equality and opens door for arbitrary decision making, Your Lordship. Therefore, this contravenes the very principles of equality before law, Your Lordship. And moreover, Your Lordship, this also raises concern according to the Article 21 of the life and liberty of a person, Your Lordship. Therefore, the citizens of Eldonia's livelihood and personal freedom is also being affected, Your Lordship. Moving on to my next contention, that is Section 8 of the Impugned Act is violative of Article 19 clause 1 clause G, Your Lordship. Your Lordship, it is humbly submitted that in a moot proposition, para number 7, Your Lordship, Section 8 of the Impugned Act grants the state the absolute right to reclaim an ownership and the management of the secret without any notice, Your Lordship. This can be violated. This is a potential violation of Article 19 clause 1 clause D, Your Lordship. Without any notice, the state has the right to take back the construction from the HDI, Your Lordship. Therefore, the council would like to submit that Section 8 lacks the clear conditions or safeguards infringing upon the right to carry on a trade and business, Your Lordship. And the absence of reasonable conditions or limitations on the state's power to reclaim thus is arbitrary and arbitrary in the interest of business, Your Lordship. And moreover, the council would like to also submit that there is a lack of regulatory or adjudicatory body. It is not being given in the provisions of the SCID Act. Your Lordship, it is very important to have a adjudicatory or a regulatory body when such absolute authority is being conferred to a public entity, Your Lordship. Private entity, Your Lordship. I beg your pardon. Actually, moving on to my next submission, that there is a lack of harmonious construction between Section 7 and Section 8 of the HDID Act, Your Lordship. Your Lordship, there is potential conflict between Section 7 and 8. Your Lordship, Section 7 confers excessive authority to the HDI, Your Lordship, and Section 8 grants exclusive power to the state to reclaim and recoup at any time, Your Lordship. Therefore, there is a lack of harmonious construction. There is a potential conflict between these provisions, Your Lordship. Your Lordship, moreover, unconscious voluntas nullum effect facit. Your Lordship, an unconscious intention produces no effect. Therefore, it is humbly submitted that if there is an inherent inconsistency or contradiction between the legal provisions, Your Lordship, the unintended consequences may render the legislation ineffective or unenforceable, Your Lordship. Therefore, it is humbly submitted that the lack of clarity and harmonious construction between the provisions of the STID Act is conflicting and therefore inconsistent in nature, Your Lordship. Your Lordship, the council would like to move on to the next submission, that is the corresponding agreement is illegal and opposed to public policy, Your Lordship. Your Lordship, this contention is derivative to a five-fold argument that firstly, excessive delegation of authority is present, Your Lordship. Your Lordship, if you could refer to the moot proposition para number 7, where it is an agreement between state government of Eldoria and HDI. Your Lordship, the council seeks extension for time. State government of Eldoria, Your Lordship, it has been absolutely stated in clause A of the agreement that absolute authority has been conferred to HDI, Your Lordship. Therefore, this signifies a concerning level of excessiveness or excessive delegation and is violative of the constitutional principle, Your Lordship. And this delegation extends to critical aspects, Your Lordship, including infrastructure development, environment control, and security, Your Lordship. Therefore, going beyond the limits, acceptable limits, Your Lordship. Therefore, Your Lordship, it is humbly submitted that this granting of absolute authority to HDI is unrestricted power to HDI without any sufficient checks and balance, Your Lordship, is therefore violative of the principles of fairness, accountability, and protection of public resources, Your Lordship. Your Lordship, it is also humbly submitted that Your Lordship, the council seeks permission for extension of time. Yes, Your Lord. Your Lordship, but the council would like to finish the submissions, Your Lordship. Yes, Your Lordship. The council would like to take the risk, Your Lordship. Your Lordship, the council would like to submit that there is unchecked discretion without limited oversight, Your Lordship. It has been stated in 7 in the moot proposition para number 7 agreement clause B, Your Lordship. It has been stated that HDI has the right to carry out the project at its will, Your Lordship, and therefore it is without adequate state oversight and represents a clear violation of the constitutional principles, Your Lordship. Therefore, granting such unchecked discretion to HDI jeopardizes the transparency expected in a public-private partnership, Your Lordship, and there is there can be potential abuse or actions that may not be in the best interest of the public. Your Lordship, the Council will also like to move on to the next submission, that is, there is ambiguity in the state's power to reclaim. Your Lordship, Your Lordship, it has been undertaken that when the state has the right to reclaim the project when the state's financial stability is when the state has attained financial stability. There is a clear lacking of benchmarks to what financial stability is, and there is no clear-cut guidelines given, Your Lordship. Therefore, Your Lordship, the constitutional due process requires that the exercise of governmental powers should be based on a clear and fair procedures, Your Lordship. Therefore, it is being humbly submitted that this clause of the agreement actually undermines the due process principle, Your Lordship. And moreover, Your Lordship, the Council would like to humbly submit that there is procedural impropriety by HDI. Your Lordship, the actions while undertaking this unconventional construction, Your Lordship, there has been procedural impropriety, Your Lordship. Your Lordship, mainly the Council would like to submit that the subcontracting of toll to Paul Sons, Your Lordship, as mentioned in moot proposition para number 10, Your Lordship, that it constitutes a violation of the legal principle delegatus not ritus delegare, Your Lordship. This doctrine emphasizes that the authorities which is entrusted with responsibility should not further delegate those powers to any other person, Your Lordship. Therefore, this excessiveness of development not only contravenes, Your Lordship, the explicit directions laid down in the statute, Your Lordship, it also undermines the very essence of the Act, Your Lordship. Furthermore, the Council would like to humbly submit the construction activities that is undertaken by HDI has established exorbitant international standard schools, Your Lordship, with exorbitant fees, Your Lordship, thus blatantly violating the core principles, Your Lordship. This is not for the welfare of the people. Your Lordship, the petitioners are normal citizens of the Eldoria, and they have built a floating restaurant, international standard schools, Your Lordship, which is not at all accessible to the common people of Eldoria, Your Lordship. Your Lordship, therefore, the Council would like to submit that the damages to be awarded by this honorable court is that the respondents are absolutely liable for the environmental degradation and harm caused, Your Lordship, and applying the polluter pays principle, Your Lordship, thus unequivocally establishes the environmental harm, Your Lordship. And therefore, the Council seeks permission to move on to the prayer. Much obliged, Your Lordship. Therefore, in the lights of the facts stated, issues raised, arguments advanced, and authorities cited, Your Lordship, it is most humbly prayed and implored before this Honorable Supreme Court of Meridiana that it may be graciously pleased to adjudge that the public interest litigation and writ petition under Article 32 of the Constitution is maintainable, that the state of Eldoria and its instrumentality, HDI, is liable for the violation of Articles namely 14, 19, and 21 of the Constitution, hold the state of Eldoria and HDI absolutely liable for the environmental degradation and loss of life, Your Lordship, and declare that the Seaport and Township Infrastructure Development Act 2022 and the corresponding agreement is illegal and violative of Part 3 of the Constitution, and award exemplary damages to be paid by the state of Eldoria and HDI for the consequential loss of life and degradation, and order and direct the government to take corrective measures to restore the degraded environmental laws, and or pass any other order, direction, or relief that it may deem fit in the interest of justice, equity, and good conscience. For this act of kindness, the petitioner shall duty bound forever pray. Your Lordship, it is a writ of mandamus, Your Lordship. It was an honor arguing before this honorable court. Your Lordship? Yes, Your Lordship. As mentioned in the prayer, Your Lordship, the Council seeks that the respondents, the court ordered direction to the respondents to undertake the construction in a sustainable manner and pay exemplary damages to those who were affected by the loss of life, and environmental degradation. No, Your Lordship. The petitions are for the development, Your Lordship. What the council is seeking to establish is it be taken care in a sustainable manner, and all the environmental degradation that has been already caused should be properly undertaken, corrective measures to be undertaken. Yes, Your Lordship. Your Lordship, it has been. Lordship, Lordship, I'm not. It's not audible, Your Lordship. I'm not hearing it properly, Your Lordship. Remodel. Oh, yes, Your Lordship. So that the prosecuted activities can be undertaken in a sustainable way and remodeled again so that it is for the benefit of the nation as well as the citizens of Eldorian, and they are given employment opportunities, Your Lordship. Much obliged, Your Lordship. And
May it please the Honorable Court. This is the council appearing on behalf of the residents in the matter of acquiring certificate and others versus state of Algeria. The council seeks permission to address the bench collectively as your lordship. And to oblige your lordship, the council, if the lordships are well versed with the issues of the case, facts of the case, the council seeks permission to proceed with the issues stated. Which oblige your lordship. Your lordship, in this particular instance, that there are mainly four issues which the respondents like to argue before the honorable bench. The first issue is regarding whether the petition is maintainable before the honorable court. Second issue is regarding whether there is violation of fundamental rights before under envisaged under the part 3 of the Constitution. And issue 3 is regarding whether the Seaport and Township Infrastructure Act and the agreement is ultra-wise to the Constitution. And fourth issue is regarding whether the constitutional activities have resulted in environmental litigation. Lordship, the first and second issue will be dealt by myself, and third and fourth issues will be dealt by the co-counsel. Lordship, the council seeks permission to proceed with arguments. That's about the Lordship. Lordship addresses the first issue, that is whether the writ petition is maintained before the Honorable Supreme Court of Mariana. Lordship, the council has three contentions with regard to the same. Lordship, the first contention is that there exists an alternative remedy that is approaching the Honorable High Court at state of Eldoria, then this particular constitutional right is given under Article 226. The Lordship, this particular right is not only a mere alternative remedy, but an efficacious alternative remedy, Your Lordship. Your Lordship, in this instance, the Council like to point out that whatever instances the move proposed to states clearly has happened in the state of Eldoria. That clearly has happened in the state of Eldoria, Your Lordship. So in this instance, High Court Eldoria dealt with the issue, Your Lordship. Your Lordship, with regarding to the same convention, the particular petitioners could have approached the Honorable High Court of State of Algeria, Article 226, as the particular article has a wider jurisdiction, Your Lordship. Your Lordship, at the same time, the councillor moves to the second convention, that is for invoking Article 32 and coming before this honorable bench. There should be. Why does your Lordship, with regard to Article 226, Article 226 is not only limited to fundamental rights, but also. Here, right. No, it is not there. Okay. Then okay, your Lordship, it is in this instance, the particular instance of the move proposed state happens in the state of Algeria, Your Lordship. As the Honorable Court has already pointed that alternative remedies have to be exhausted before coming upon the Honorable bench, Your Lordship. According to Your Lordship, the operational guidelines by the upper court in this regard, by the Supreme Court. Your Lordship, in relation to approaching of High Court first, what are the approaching Your Lordship, Your Lordship, Your Lordship, with regard to approach to Honorable Court, under Article 32, there should be violation of fundamental rights, Your Lordship. Indeed, Your Lordship. So, Your Lordship, as the petitioner stated, there is no violation of Article 14, Article 19, and 21. Thereby, there is no application of the Golden Triangle rule, Your Lordship. Because Your Lordship, in this instance, there is no violation of fundamental rights. The actions of the state has not resulted in any of the violations, Your Lordship. Yes. Can you cite any authority, any decision in support of the convention that it is better to approach under High Court under Article 36? Your Lordship, as in the case of approaching High Court, the council had to point out that in order to whether there is a court of convention,
Yes, no,
The council fees minutes of the government.
any of them, in relatively, very about
You know, actually, this directly approach to the honorable superior. Lordship, in that particular instance, it was more of a national interest issue. It is more of a national interest issue, but it is more of a national interest issue, Lordship. So, you know, the actions of the state was not only limited to the religious minority group, it extended to the coastal inhabitants of the state of Eldavia. So, in this particular group, there could be individuals who were agreed by the stand, who would not have been agreed by the stand of the government of the law. So in such an instance, Your Lordship, the remedy would not be effective for the petition itself, Your Lordship. If it was in the form, if it was in the form for public interest litigation, Your Lordship, it is understood that it is for the general interest of the coastal inhabitants of the state. But in this instance, Your Lordship, they come before the honorable court. In this instance, Your Lordship, they come before the honorable court seeking a writ petition. That is the fundamental aspect of writ petition is that there should be a individual's rights should be agreed. And Your Lordship even makes numerous cases with regard to locus standi. It was held that a particular individual or a group could approach if that particular group's individual right is being violated. But in this instance, Your Lordship, it's very much unclear with regard to that, and the petitioner has not established the same, Your Lordship. Apology, Akshay. Your Lordship, seven people has died in the span of 4 months, Your Lordship. But it is not stated in the move proposition that the death was caused by this particular construction, Your Lordship. Your Lordship, the death of the particular fisherman community in this coastal inhabitants do venture out in the sea for their source of livelihood. So at the point of venturing into the sea, there could have been other hazards or perils which could have resulted in the death, Your Lordship. There is no material fact that which articulates the death to the particular construction, Your Lordship, or the actions of the state, Your Lordship. Your Lordship, in this instance, the state has taken precautionary principle and has also resorted to the concept of sustainable development, Your Lordship. Your Lordship, in this instance, the state wanted to establish this particular seaport on the instance that this will enable the particular state to grow to certain levels in the interest of the general public. Your Lordship, here, the state very large, indeed. So, Your Lordship, council like to point out that the state has adopted the precautionary principle in this instance because the state has already enacted a legislation. Indeed, Your Lordship, here the public interest is what is taken into consideration, Your Lordship. Here, what the state is trying to establish is that the growth of the particular state, thereby creating employment opportunities for the individuals. And with regard to the Lordship, with regard to the precautionary principle and the other legislations, the EIA and this result will be dealt by co-council, Your Lordship. Your Lordship, with regard to the first issue, that is whether the petition is maintainable, these are the humble submissions made up before this court. The council now seeks permission to proceed with issue 2. Your Lordship, issue number 2 deals with whether there is a violation of fundamental rights stated under Part 3 of this Constitution. Your Lordship, the Council of completely condemns that there is no violation of fundamental rights legislation under Article 21, Article 19, and Article 14, Your Lordship. Lordship, Article 21 do state the aspect of right to life. It is guaranteed upon all the coastal inhabitants in the particular state. Lordship, the Council like to quote the decision in State of Maharashtra versus Basan Mohanlal Ketan, 1986, SCR 1, 7077. I quote, the Constitution does not put an absolute embargo on the deprivation of life or personal liberty, but such deprivation must be according to the procedure established by law which must be fair, just, and reasonable. I unquote. Your Lordship, in this instance, the legislation or the piece of procedure which the state has enacted is the SWIFT Act 2022. Your Lordship, it can be seen that before even enacting the particular legislation, the state has already heard the requests or has consulted with the particular coastal inhabitants of the state, Your Lordship. The state has taken account of all their concerns with regard to their employment, with regard to their rehabilitation thing. And Your Lordship, the state has also agreed with regard to the MOU that they will be given preferential employment. And the MOU does not state that at what stage, but they will be provided their employment. And it is also to be noted that by means of the MOU, their customary fishing rights is also guaranteed to them, Your Lordship. So the particular legislation does not infringe or takes away anything which contravenes Article 21, Your Lordship. Your Lordship, even if we take a look at the provisions of the SWIFT Act, Your Lordship, it can be inferred that the state has only seek to protect the interests of the particular public, Your Lordship. Lordship, while referring to Section 7, Clause G, it can be seen that the state has even invoked a provision which says that undertake, execute, and perform such works and activities and studies to promote maritime education, training, skill development of coastal communities, seafarers, welfare, and port-related development. Lordship, in this particular instance, it can be seen that the particular state is indeed seeking to protect the rights of this particular coastal community, training them in such a way that their right can be protected and their well-being can be ensured. The state is indeed looking into the public development or public interests at large, Your Lordship. Therefore, the state is trying to consider all these elements, Your Lordship. Therefore, Your Lordship, the Council humbly submits that there is no violation with regard to Article 21 in means of right to life, Your Lordship. Lordship, the next contention is regarding the environmental degradation, Lordship. Your Lordship, the more proposition states that the unconventional construction resulted in environmental degradation. But at the same time, Your Lordship, it states the kind of environmental degradation that has happened in this instance. It says that Your Lordship, kind attention to paragraph number 11 of the more proposition, Your Lordship. Your Lordship, it states that huge perennial deposition of sand brought by the waves at the mouth and inside of the channel, Your Lordship. Your Lordship, here the deposition of sand may not be the deposition of sand may not be only caused by human activities, but it could also be caused by natural causes, Your Lordship. Lordship, in the memorial submitted by from the respondent side, under page number Your Lordship, on page number 16, the survey regarding British Geological Institute has been incorporated, which says that natural circumstances could also lead to sand deposition at the mouths and at the entrances of the navigation channel, Your Lordship. Your Lordship, a comparative study has also been presented before this honorable court with regard to a study conducted by the Bay in China, Your Lordship. Lordship, the council seeks permission to submit with regard to that, Your Lordship. Your Lordship, this particular document shows us that even natural causes could lead to sand deposition in this instance, Your Lordship. It's not, it could be there is a huge probability that it could be the sand deposition could be due to natural causes, Your Lordship. But okay. Your Lordship, as per the move proposition, the next impact, which is the causing of height of the wave being increased, Your Lordship. But, Your Lordship, in this instance, the seaport construction is an activity. Apologies, Your Lordship. Council seeks permission to rescind, Your Lordship. That's right, Your Lordship. Your Lordship, with regard to the height of the waves increasing naturally, it's not actually taken off. Apologies. Your Lordship. Your Lordship, with regard to the particular environment degradation, there has been no scientific data to prove that this particular construction that has resulted in the so and so environmental degradation, Your Lordship. Your Lordship, and also with regarding to the height of the particular waves increasing, it is this particular sand deposition that causes the waves height to increase naturally. So when the sand is being deposited, the shallowness of the sea is being increased. At the same time, the height is being increased. So, Your Lordship, it is primarily the deposition of particles is the cause, and that particular deposition should be caused by natural factors, Your Lordship. That is what the council operates under this meant, Your Lordship. So, in this regard, Your Lordship, there is no environmental violation by actions of the state, Your Lordship. India, Your Lordship, India. But Your Lordship, sand deposition is dangerous, but it is not cause actions of the state, Your Lordship. Your Lordship, the sand, even the sand deposition here, the state has not caused the particular sand deposition to happen in the particular instant, Your Lordship. It could, uh, Indeed, Your Lordship, it is not on account of this particular project that the particular sand deposition has taken place. Over the span of 12 months, where the project was conducted, natural forces could have articulated the sand deposition in this particular area, Your Lordship. So, in this instance, as there is no environmental degradation, Your Lordship, the claim submitted by petitioners with regard to right to life and right to environment cannot be substantial, Your Lordship. At the same time, Your Lordship, the particular respondents are not preventing the fishermen community or the coastal inhabitants to carry on their trade or their livelihood sources, Your Lordship. They do have the freedom to practice their customary fishing rights. Nowhere in the particular no proposition or in the SIT Act it is stated that the fishermen will be subjected to the profession only which the state guarantees them. No, the particular petitioners have their liberty to carry on their profession, Your Lordship, in this instance. And therefore, it humbly contended before this bench that there is no violation of Article 21, Your Lordship. Lordship, the council now moves on to the second sub-issue, that is regarding violation of Article 90. Lordship, the council is well aware of the concepts of occupation, profession, trade, enlisted under Article 19. Lordship, it can be attributed that this particular incorporation is related to the source of livelihood for a person. But Your Lordship, in this instance, Article 19, Clause 1 is subject to various reasonable restrictions, Your Lordship. The council would like to rely upon the decision in Municipal Corporation Ahmedabad versus Jan Mohammed Usman Bad 1986 to SCC 20, Your Lordship. In this decision, Your Lordship, it was held that the expression of interest of general public in Article 19, Clause 6 is of wide importance, comprehending public order, public health, public security, morals, and economic welfare of that particular community. Your Lordship, the state has enacted this particular legislation state has enacted this particular legislation with regard to economic welfare and public development, Your Lordship. So it falls under the reasonable restrictions brought under Article 19, Clause 6, Your Lordship. Your Lordship, that and this particular whole project for the state of for the state of Algeria is for the general interest of the public. This will promote more employment opportunities, more development to the whole of the coast, Your Lordship. Your Lordship, apology, Lordship. Apology, Lordship.
Maybe in both.
Indeed, Your Lordship.
On which ground?
Your Lordship, it should not be violating of the principles.
Reasonable restrictions can be maybe in both. On the ground of which ground? As far as right to carry on trade, business and occupation.
With regard to the economic policy and general interest of the public, Your Lordship.
Please, propose.
Your Lordship, the council seeks an additional 2 minutes.
That is one clause one.
Lordship, nothing in subclause C of the said clause shall affect the operation of any existing law as it opposes or prevent the state from making any law enforcing in the interests, the sovereignty and integrity of India or public order or morality, reasonable restrictions.
Restriction in relation to right to carry on trade or business or occupation, that is 19(1)(g).
In the Lordship. Only Lordship.
It's not a question. Reasonable restriction may be given in 19 clause 4, I think. 19 clause 4 or 5.
9 clause 4, Your Lordship. Lordship, nothing in this subclause or the said clause shall affect the operation of any existing law or insofar as it imposes or prevent the state from making any law imposing in the interest of the sovereignty and integrity or public order or morality and reasonable restrictions on the exercise of the right conferred by the said subclause. Your Lordship, moving on to clause 5, nothing in subclauses D and D of the said clauses shall affect the operation of existing law insofar as it imposes or prevents the state from making any law imposing reasonable restrictions on the exercise or of any of the rights conferred by the said subclauses in the interest of the general public or for the. Yes, Your Lordship.
Please say one sentence. How interest of general public is protected here?
Indeed, Your Lordship. Your Lordship, here this particular project falls under the exception of general interest, general public interest, Your Lordship. Lordship, in this instance, it can be seen that from the first paragraph itself, the state of Algeria is a state which depends upon coastal resources. And the one thing which the particular state used to lack was the seaport. And so they had to rely on the seaports of other neighboring countries or the neighboring states. And because of this, they used to incur huge transportation and freight charges, and at the same time, there used to be a substantial delay, which also resulted in soaring high import costs of certain raw materials. So, Your Lordship, the standard of living in that particular region itself is going high on the first instance, Your Lordship. The standard of living in the particular state itself is going high due to the lack of the particular seaport, Your Lordship. Therefore, Your Lordship, in this instance, the seaport is in need of our Your Lordship. Lordship, even by bringing the seaport and the township, Your Lordship, the state is seeking to create employment opportunities, Your Lordship. Lordship, if Your Lordship's kind attention is taken to paragraph number 10, it can be seen that particular township that was constructed is constructed of offices, malls, two schools of international standards, which have a huge fee structure. At the same time, a floating five-star hotel. Your Lordship, all these constructions will attract foreign direct investment to the particular stadium. Much obliged, Your Lordship. Your Lordship, the council seeks permission. Quite right. Indeed, Your Lordship. Indeed. Occupation fee. In Your Lordship, Your Lordship, even with the traditional occupation being sacrificed, the source of livelihood should have to be maintained, and it's the duty of the state to ensure that. Therefore, this project is in the general interest of the public. Much obliged, Lordship. Lordship, and apologies, Lordship. Your Lordship, Your Lordship, here there is no application golden triangle principle as this falls under the reasonable restriction. So, Your Lordship, as there is a violation of Article 19, as there is no violation of 19, and the state of exercise is reasonable power under Article 19 clauses, there is no violation of the golden triangle principle which has been established, and there is the golden triangle consists of Article 19, 14, and 21, Your Lordship. This instance, there is no violation, Your Lordship. Lordship, the council now seeks permission to proceed with the last submission with regard to Article 14. Your Lordship, in this particular instance, the petitioner did claim that there was violation of Article 14. Your Lordship, here the particular legislation of SWIFT Act is not discriminating anyone on the basis of any criteria, Your Lordship. Here, what the particular enactment is being done is to, as the preamble of the particular act states that this particular act is for providing plan, construction, regulation, and operation of the elderly seaports and its administration, control, and managing, facilitating infrastructure development, and for matters connected there with the incidental thereto. Lordship, here, the purpose of the whole act itself is seeking to promote the particular port development, and at the same time, this particular legislation incorporated various provisions such as Section 7 Clause G, where the rights of the particular people would also be protected. And here, there is no absolute power vested upon this particular authority called HDI. The state also has absolute control there, and the state also by means of an agreement has entered has agreed that the particular HTI, the particular private company, should also comply with all necessary legal and procedural compliance with the lordship. And this company submitted that there is no violation of Article 14 of the lordship. Lordship, in light of these arguments, Lordship, the Council humbly submits before this honorable court that there is no fundamental right violation, there is no application of the golden triangle as Article 14, Article 19, Article 21 is not violated, and in henceforth the petition has been dismissed as there is no fundamental right violation, Your Lordship. Your Lordship, if you are not satisfied with the arguments advanced, there is no further questions. The Council seeks permission to call upon the court.
You are G13 plus 1. S1.
S1, Your Lordship. Reading this formal code, this is council number 2 appearing on behalf of the respondents. Council seeks permission to address the bench selectively of their lordships. Much obliged, Your Lordship. The council will be dealing with two issues. Issue number 3, whether the Seaport and Township Infrastructure Development Act 2022 is authorized as a constitution. Issue number 4, whether the construction activities have resulted in the very environmental degradation. The council seeks permission to begin arguments for issue number 3, Your Lordship. Much obliged. At this juncture, the council will be dealing issue number 3, that is whether the Seaport and Township Infrastructure Development Act 2022 is ultra vires the constitution. Lordship, the proposal to build an international seaport in the state of Eldoria was motivated primarily by two objectives. Number one, to expedite export and import process. Number two, to establish Eldoria as a major participant in the regional maritime industry. For years, the state of Eldoria has been depending on neighboring states and other countries for sea transport facilities and which caused the delays and soaring import costs. In addition, the Chief Minister of the state of Eldoria in the press conference conducted on December 8, 2023 has stated that the very project is a policy of the government. Hence, the particular proposed project is policy of government and is constructed in public interest. But due to the COVID-19 pandemic and financial challenges, the government, to ensure the continuity of the seaport project, has sought public-private partnership and enacted the very statute, that is the Seaport Township and Infrastructure Development Act. So it was enacted to appoint authority for planning, execution, and management of infrastructure projects in the state of Eldoria.
With regard to the constitutionality of the particular statute, Your Lordship, the Honorable Supreme Court in the case St. John's Teachers Training Institute versus Regional Director NCCE, reported in the year 2003, volume number 3 of SEC, page number 321. In para 12, the court observed that whether particular legislation suffers from the vice of excessive delegation has to be examined in the context of subject matter, scheme, or the provisions of the statute, including the preamble. In the case at hand, the preamble states, I quote, an act to provide for planning, construction, regulation, and operation of Eldorado seaports and its administration, control, management, and facilitating infrastructure development and for matters connected therewith or incidental thereto. I unquote. In addition, Section 8 of the statute gives the state the right to reclaim the seaport at any time if any type of environmental degradation is detected. In the case at hand, in furtherance of this statute, there are several legislations which have overriding effect, which are the Coastal Regulations for Notification 2019 and the Environment Impact Assessment Notification 2006, which acts and supervises the project plan, the impact, and give appropriate direction and conditions as part of the clearances. Also, Clause 8, Clause 6A makes it mandatory for the project proponent to submit half-yearly complaints reports with respect to the stipulated terms and conditions in the environment clearance. Your Lordship, it has been noted that the seaport construction is at its initial stage and the commissioning of the seaport will be.
So this case is related to environmental issue. The case is like
No, Your Lordship, the council is stating with regard to the particular constitutionality of the statute. The fact is, with regard to the challenging of the National Council Teachers Training Regulation 2002, particular regulations challenge the Regulation 5. Regulation 5.
so okay. It's all right. So if the subject is concerned with this in the concerned list, and there is a central legislator,
The reasonable convention.
is a case of legislation by state government. The doctrine of excessive legislation is not a problem.
It's illegal. Illegal.
So it's a correct.
Can you repeat the question, Your Lordship?
Your argument is that there are so many central legislations and regulations for controlling it. So there is no question of excessive delegation here. This logic is applicable in education sector. This doctrine is not applicable because there are so many regulatory agencies.
Any Lordship or
I am questioning the rationale of your argument.
If Your Lordship. The council was guiding the honorable bench to that there are other provisions which makes the particular statute within the framework of the constitution, Your Lordship. Your Lordship. Also in furtherance, clause C of the subsequent agreement states that the particular project proponent, that is a private company, shall follow all the legal and procedural compliances. So if there is any type of environmental degradation is detected, the state in furtherance of section 8 of the particular statute will reclaim the project or will do appropriate action for correcting or reversing the damage that ecology. But also in furtherance of the preamble, section 8 and the subsequent agreement, the powers of the authority are limited and subject to the state supervision, and the provision does not violate the fundamental rights, thereby making the Seaport and Township Infrastructure Development Act infra violates the Constitution. If your lordships are satisfied with the submission, the council is humbled to answer any question that arises here. The council seeks permission to move on to issue number 4. Issue number 4, your lordship, whether the construction activities have resulted in environmental degradation. In the instant case, the petitioners allege that the unconventional construction led to environmental degradation, resulting in deposition of sand in the channels of nearby harbors brought by whales, making navigation of fishing vessels difficult. Here, the cause for the degradation raised by the petitioner is the deposition of sand by whales. My co-counsel has already cited two studies, the British Geological Survey and a case study titled Influence of Waves and Currents in Sediment Erosion and Deposition based on in-situ observation. Both these studies in abstract show that sand deposition may also happen due to natural factors. So there is an exception. In the instant case, the petitioners have not submitted any direct evidence or scientific proof to prove that the constructional activities of the seaport have resulted in the alleged environmental degradation. So it is highly necessary in the interest of justice to have sufficient proof for the allegations raised. In the current case, there are primarily two legislations which govern the implementation of the proposed project. Number one, the Coastal Regulation Zone Notification 2019, and number two, the Environment Impact Assessment Notification 2006. According to Clause 7, Subclause 3, since the proposed project falls under all the coastal regulation zone,
Yeah. Notification.
yeah,
Which act?
these notifications are issued in furtherance of Section 3 of the Environment Protection Act 1980. So, since the proposed project falls under all the coastal regulation zones of the area, seaport falls under CRZ 1 area and 4, and the township falls under CRZ 2 and 3. So, since the seaport falls under CRZ 1 and 4, and all the townships, both the proposed project falls under all zones. So, in furtherance of Clause 7, Subclause 3, the clearances shall be dealt by the Ministry of Environment, Forests and Climate Change in central government based on the recommendations from the Coastal Zone Management Authority. Also, secondly, the Environment Impact Assessment Notification 2006, Clause 2 provides that prior environment clearances from the central government in Ministry of Environment and Forest Climate Change for Category A projects and Category B projects. The particular seaport falls under Category A projects in furtherance of the schedule number 7E of the Environment Impact Assessment Notification 2006, and township falls under Category B. So therefore, in the instant case, the clearances shall be sought from the central government based on the recommendations of the State Environment Impact Assessment Authority. In the instant case, the project was initially decided to be undertaken by the state government. Therefore, necessary prior environment clearances were sought. But due to the financial problems and the COVID-19, the state was forced to appoint another authority to complete the project, and license was issued by the authority in furtherance of the clearance and environment assessment. Your Lordship, the proposed project is implemented in public interest and in furtherance of the directive principles of state policy by clearly laying guidelines and powers, especially with regard to Clause 8, Subclause 6, which of the Environment Impact Assessment Notification, which states that half-yearly complaints reports shall be submitted by the project proponent to the appropriate authority, so that they will follow the conditions and terms stipulated in the environmental clearance. So this ensures that the project proponent will not interfere with the environmental balance of the nature laws. So also, in furtherance, the government from time to time have engaged in negotiations with the natives for addressing their concerns. The respondents thus have taken appropriate measures to address various issues of the project, while at the same time, state has to balance the public interest also. The council humbly relies on the case Indian Council for Enviro Legal Action versus Union of India, reported in the year 1996, volume number 5, SEC, page number 281. The Honorable Court observed that both development and environment must go hand in hand. Economic development should not be allowed to take place at the cost of ecology, while at the same time, the necessity to preserve ecology and environment should not hamper economic and other developments. Your Lordship, the petitioners and the coastal residents have created riots and chaos with regard to a particular police station in the nearby seaport. So, in furtherance of that problem, the Chief Minister in the press conference has stated that the concerns will be addressed. While at that particular instance, the petitioners had approached the Honorable Supreme Court for a remedy. The stand of the humble contention of the respondents is that the state government, will appoint an independent expert committee consisting of an ex-judicial member and expertise in environmental matters from the National Environmental Engineering Research Institute, and a technical expertise who is having the particular expertise in the seaport construction, and a member from the fisherman community. So, in the complete rendering of justice and in the interest of public, the concerns of the petitioners will be addressed by the government in furtherance of the report from the independent expert committee. Your Lordship, the humble contention of the respondents is that in that particular instance, there is no direct evidence or study done to prove that the constructional activities have caused the alleged environmental degradation. Therefore, the construction of the proposed project is according to the procedure established by law, and there is nothing in contravention of any laws in effect. Hence, the constructional activities have not resulted in the particular instance in any environmental degradation. If your lordships are satisfied with the submission, the council will be humble to answer any question that arises here. If your lordships are satisfied, the council. Indeed, Your Lordship. The precautionary principle here is applicable with regard to the CFS clearances and the environment clearances. So there, the clearances are so prior to the proposed project. So government will submit the appropriate project plan, wherein the central government, based on the recommendation. So that you need to focus that. You have an answer that. Indeed, Lordship. The central government will issue. Yes, Mr. Washington, understand the concern. The central government will issue certain conditions so that the particular project opponent shall not, the activities of the particular project opponent shall not result in any environmental degradation. So, to ensure that half-yearly compliance reports shall also be. We have a word on what is the guarantee? The two things are that is question number one. The two things are two ways. Was or we the contract or private part. Then anybody to regulate it. Anybody to ask. How do you conduct it? How do you meet that happen? I want to know how do you meet that happen? For this lordship, I am waiting. But then there is no regulator at all. He says that. Therefore, how do you meet that happen? You know, they stand. Giving existence is like existence won't say. So how do you meet that happen? Legally. The legally, your lordship, in furtherance of the notifications only, the central government and the state government has supervisory power with regard to the construction activities of the project of foreign lordship. He started to globally, you global implementation to project. He's asking you what is the guarantee for our life. Right? He says that the life is saved. Therefore, it is connecting him and I mean that general principle, but also Article 21. He says that right to try. How you do it? Your Lordship, the very fact is that the seaport construction is at the initial stage. Your Lordship, that is why from the Council for the Respondents Assembly conduct that the independent expert committee will look onto the concerns of the particular petitioner, and if there is any merits on the particular allegations placed, the state will act in accordingly, Your Lordship. And also in furtherance, section C of the subsequent agreement states that the project opponent shall compulsorily follow the legal and procedural compliances, and section 8 provides the state to reclaim the project at any instance when there is any type of environmental degradation or any violation of particular laws in effect in the country of Maritime Laws. What do you say? That is why you also the council condemned that the seaport construction is at the initial step, and it is in the interest of justice and complete rendering of administration of justice that the appropriate committee report shall be relied upon to further the arguments of the particular case, Your Lordship. Case of plan. And God will go. Yes, indeed, Lordship. The Lordship, the process taking the particular actions, the state government is addressing the very concerns with regard to the possible resident, and at the particular instance, they have approached the honorable court. Oh, no. Indeed, Lordship. Indeed, Lordship. The petition shall be dismissed after the report of the committee. Lordship. Independent expert committee. Apologies, Your Lordship. The petition is immature. I didn't understand, Your Lordship.
Okay. What is your response to the argument founded on this absolute liability? With regard to cooperative research,
Your Lordship, the liability can only establish with the scientific proof or studies, Your Lordship. In the particular instance, Your Lordship, without sufficient proof, 17. Yes, yes, in Lordship. But there is no proof to say that in the particular instance that the constructional activities have resulted in the very particular Lordship. The Indeed, Lordship. Your Lordship, can you please repeat the question? I didn't get it.
what about the cooperative federalism?
Yeah, that is why, Your Lordship, the state government has approved the central government for the clearances, and it is in the concurrent list. So the central government has given the clearances, and they have not made any obstructions with regard to the construction activities, Your Lordship. And the license was issued, which is stated in paragraph 12 of the note proposition by the competent authority, Your Lordship. Worship. Worship, the council seeks permission to move on to prayer. Wherefore, in the light of issues raised, arguments advanced, and other
Your Lordship, council like content that, as Your Lordship rightly pointed out, that in Mahatma Gandhi versus India, Mahatma Gandhi has approached the local standing to the Honorable Supreme Court under Article 32, Your Lordship. And therefore, Your Lordship, thus the right to approach the Supreme Court is a fundamental right in itself, Your Lordship, and therefore, and moreover, the council also right to submit that, Your Lordship, the fundamental rights violation extends beyond the immediate aggrieved party. Therefore, the petitioners has the sufficient interest and local standing in the present case, Your Lordship. Your Lordship, moreover, moot proposition paragraph number 11, page number of the moot proposition, Your Lordship, explicitly states that the unconventional construction has led to the substantial deposition of the sand, Your Lordship. Your Lordship. Therefore, Your Lordship, the learned opposition council cannot contend that it is a course of natural course of action, Your Lordship. This unconventional construction has accelerated in the deposition of the sand, thus causing the rise of water levels, Your Lordship. Thus, moreover, the council would like to humbly submit that a pilot study, Your Lordship, under Oxford Dictionary, it defines that pilot study is a small scale preliminary study conducted to evaluate the feasibility and the cost related to a research project, Your Lordship. And therefore, the respondents contending that a pilot is not sufficient, Your Lordship, while undertaking such a large scale project, Your Lordship. Therefore, it has to be possible to note that there is no environmental impact assessment done, and a pilot study is not just sufficient, Your Lordship. And therefore, Your Lordship, the council also like to humbly submit that the memorandum of understanding has promised preferential employment rights, Your Lordship. Proposal of exclusion deployed by the respondents is violative of Article 14 and N plus 1 plus D, Your Lordship. And moreover, Your Lordship, the council would like to submit that the respondents were negligent and reasonable duty of care was not conducted, was not taken care by the respondents while undertaking the construction, Your Lordship. Moreover, Your Lordship, therefore, the council would like to submit that the respondent is not just acting on the public interest, Your Lordship. As pointed out, there is a profit over, Your Lordship. Hiring cheap laborers from the northeastern state. It has a profit motivated underlying behind the invention, Your Lordship. Therefore, the council would like to humbly submit that this is